Correct.
Yes,
Yes.
many others like something.
Yes. So
it shows units.
So welcome to everyone. So I am Anna Vatsile Prate. I have here written that I represent the Alliance of NGOs. Yes, I also represent the Alliance, but I am one of the founding director of an organization that is called KENIS, Knowledge for Safety and Good Governance. So we have today several speakers. This meeting is going to advance on the work that has been done by a working group that is dealing with gender-based violence as a form of non-state torture. We have summarized the work done so far in a written paper that has been submitted by the International Association of Democratic Lawyers to the Commission. You can find it in the documentation, official documentation of the Commission. And Evelyn Durmeyer also made an oral statement yesterday for the Commission to reiterate some of these issues. The topic is very important. We don't want to change the definition of torture, you know, in reality. So we would like to reassure everybody, but we would like to make sure that a very important framework as the Convention Against Torture can be applied also to other forms of very, very serious crime, such as gender-based crimes that are de facto a form of torture. So advancing on conceptualization and making sure that the steps forward that have been made in the conceptualization of torture, they are not taken back. At this point, I would like to give the floor to the ambassador, but the ambassador is on her way. So maybe I could ask Ben to start bringing us into the broad area that we are dealing with.
Thank you so much. Thank you, Anna. I'm Sven Pfeiffer from UNODC's Crime Prevention and Criminal Justice section, and I'm happy to be part of this event. Thank you for inviting me. I think it's important to recall that almost 1 in 3 women worldwide experiences some form of gender-based violence in her life, and that violence by a husband or a male intimate partner remains one of the most widespread forms, according to the latest prevalence statistics that we have from WHO. And our own UNODC's global homicide data actually reveals the lethal nature of that kind of violence, because we know that women account for 6 out of every 10 homicide victims who are killed by their intimate partners or by their family members. And UNODC's last femicide brief highlighted that every hour, more than 5 women or girls are killed by someone in their own family. And these figures illustrate, I think, that state responses to gender-based violence are still incomplete and insufficient, and much more needs to be done to live up to the international commitments, both legally and politically, for example, thinking of SDG 5, to eradicate all forms of violence against women and girls by 2030, as states have committed on. And that's why it's timely to have a discussion on how to strengthen the due diligence obligations that states have under international law to prevent and address gender-based violence against women and girls, and what role the definition or framework of torture can play in this regard. And it's important in that regard, I think, to recall the work of feminist international human rights lawyers like Linda Copeland in the early 90s, who started campaigning about violence against women as a violation of human rights and women's rights as human rights. Highlighting the needs of states to take violence against women by non-state actors seriously, Copeland described how the kinds of violence perpetrated by private individuals, often men against their wives or intimate partners, were very similar to acts of state torture. And she also challenged the idea that domestic violence is a private matter and that the state does not have any responsibility to address it. In following advocacy by her and many other women's rights activists, the 1993 UN Declaration on the Elimination of Violence Against Women actually recognized this violence as a human rights violation with corresponding obligation on states And importantly, I think it's important to recall that it includes all forms of physical, sexual, and psychological violence, according to the declaration, whether this occurs in the family or in the broader community, or whether it's perpetrated by the state or condoned by the state. And the declaration also affirms that states have an obligation to exercise due diligence to prevent, investigate, and punish violence against women, whether those acts are perpetrated by the state or by private persons. And since the early 90s, this due diligence obligation, I think, has been firmly recognized. We see it in international and in regional conventions against gender-based violence. And it's a public priority, not just in the criminal justice system, but also in the health sector in many countries. And in fact, important for us, the due diligence obligation of states is recognized in an instrument that was negotiated in this very commission, which is called the Updated Model Strategies and Practical Measures on the Elimination of Violence Against Women in the Field of Crime Prevention and Criminal Justice. It went to the GA, it was adopted in 2010, and it says that states must exercise due diligence and take relevant measures to prevent, investigate, and punish the perpetrators of violence against women, to eliminate impunity and provide protection to the victims, and that failure to do so violates and impairs or nullifies the enjoyment of women of their human rights. And since 2010, UNODC has been working on this topic. I'm happy to say that we have supported over 50 countries since then in implementing this important instrument, doing technical assistance ranging from supporting criminalization, legislative reform, to enhancing victim support, but also data collection. I think I mentioned the homicide statistics that our office collects. And ensuring that the criminal justice system is part of a holistic, multi-sectoral response is a particular challenge we see in practice and should be a priority. We've worked with other NGOs and international or UN Women and other partners to provide tools for a holistic, multi-sector response. But we think it needs to we need to go one step further, and we just published a background paper on femicide review committees, which we think is a unique practice and opportunity for in-depth reviews to be carried out by different stakeholders sitting around the table, looking at why women had to be killed and what happened not just in the criminal justice system, but also previous contacts with health and other sectors. Because we know there's a continuum of violence, and the killing is not a spontaneous act in most cases. Unfortunately, there have been many incidences, and many times states fail to adequately respond, ultimately, often resulting in femicide. So in conclusion, I believe that rethinking the definition of torture may have the potential to strengthen the existing due diligence obligation of states to prevent and address gender-based violence. But the challenge, I think, will be to ensure that this complements holistic, multi-sectoral, and survivor-centered responses without leaving behind those who experience violence that does not amount to torture. Thank you very much.
Thank you. Thank you very much, Sven. I was really to welcome Ambassador Frege, and apologies that we started. We wanted to be sure that we are going to do the entire program, but I would like to thank you for your opening remarks.
Thank you very much. I really apologize too, because of some issues.
No problem.
Yes, I'm so sorry. Good morning, distinguished delegates, representatives of civil society, dear friends. It is a privilege and an honor for me to address you on behalf of the government of Honduras as one of the co-organizers of this parallel event on gender-based violence perpetrated by non-state actors as a form of torture. First and foremost, allow me to express my gratitude to the Alliance of Civil Society Organization on Crime Prevention and Criminal Justice for inviting Honduras to sponsor this event. It is truly an honor for us. Honduras attaches great importance to this partnership in raising awareness about the urgent need to openly and honestly discuss gender-based violence with various stakeholders, including civil society and academia, and to rethink the definition of torture, and suggested by the title of our parallel image. As most of you are aware, the government of Honduras is being led by a woman for the first time in its history. President Xiomara Castro Sarmiento, her government embraces the vision of a government for and with women, and the protection of women's human rights ranks among the highest priorities on her agenda. This is the fourth occasion for Honduras to participate in this discussion. Deputy Secretary Julissa Villanueva, who is part of this distinguished panel, joining us this morning alongside Carla Gersman, Manfred Novak, and Sven Pfeiffer, brings not only her expertise as a pathologist and a woman in charge of security, crime prevention, and combating crime in Honduras, but above all, the voices of the victims confirming the timeless and the necessity of this discussion. Deputy Secretary Villanueva contribution bears witness to the violence suffered by women simply because they are women, ranging from domestic violence and sexual violence to femicide. Gender-based violence represents the most pervasive violation of human rights. Carla Gersman raises the question, why reimagine gender-based violence as torture? She describes the limitation of the current narrative, including the perception that gender-based violence belongs to the private sphere. She agrees with Manfred Noah on the principle of due diligence, which obligates states to protect women for gender-based violence perpetrated by non-state actors. The common thread is in the contribution of Carla and Manfred leads me to pose the question of whether, as a part of this due diligence to effectively protect victims and prosecute perpetrators, it is necessary to rethink the definition of torture, incorporating gender-based violence as one of its elements, as current frameworks would be insufficient. The purpose of the following discussions aim to delve precisely into this matter. Let me conclude by expressing my gratitude once again to each of the panelists of their contribution, to our co-organizers, colleagues, and to our moderator, Ana Albaz, and to all those present for attending this event. Thank you very much.
Thank you, Ambassador, and really our gratitude to Honduras for supporting this initiative since the beginning. As you said, this is the fourth time that you publicly support events in this area. And as the current president of GRULAC, Ambassador Freire also organized a briefing for the GRULAC countries on these issues that was very useful to exchange views and collect the perceptions of other states on these issues. So thank you very, very much. We have heard from Sven very important initial reflections. We have heard also that sometimes it's as important as disaggregating statistics to start to learn something more on these problems. And so now I would like to give the floor to Professor Carla Gersman, who will elaborate on these issues much more. Please, Carla.
Thank you so much. Good morning, everyone. And it's a great honor and a great pleasure to be here. This issue is very close to my heart. I come from the background of working on torture cases for many years. And there is this wrong thought that torture has to do only with men in prison. And that simply hasn't been my experience, and it hasn't been most people's experience working on torture day in and day out. Why should we reimagine gender violence as torture? The CEDAW Convention doesn't cover violence against women directly. In any event, the CEDAW is not wide enough in its mandate to cover all forms of violence, which is directed against the person because of that person's gender identity, or gender expression. Also, torture has a strong stigma and a very clear normative framework. There are positive obligations to prevent, prosecute, or extradite, and to afford reparation. But most importantly, why shouldn't we? Why should we not recognize gender violence as torture? That torture was classically associated with the administration of electric shocks or other ill treatment to men in prisons doesn't mean that we need to stay bound by that originalist narrative. The definition of torture says nothing about gender. Obviously, we should give meaning to the definition in the most inclusive way. It's quite simple. How do we reimagine torture? What are the constraints? To what extent does gender violence fall within the elements of the crime of torture? Do we even need to reimagine? In my view, it's really there. We just need to use it. Looking firstly at severe pain or suffering, whether physical or mental. Clearly, gender violence can be sufficiently severe in its consequences, both physical and mental. International criminal law case law recognizes that some kinds of gender violence are inherently severe. But any gender violence can, depending on the circumstances, meet the threshold of severity. Each case should be considered on its merits, not just the most obvious cases of rape. To limit the discussion to rape in relation to the broad plethora of gender violence would not be helpful either. What about the specific torture, the specific purpose that torture requires? For an act to constitute torture, it must have been carried out for a specific purpose, such as to elicit a confession, or to discriminate or humiliate the victim, to instill fear in communities. The International Criminal Tribunal for the former Yugoslavia, the jurisprudence has made clear that violence on the basis of discrimination or humiliation satisfies the purpose requirements. And this is a clear part of the jurisprudence of the Committee Against Torture, of the Human Rights Committee, and a range of other bodies. Also, at least in a detention or coercive armed conflict context, rape carried out supposedly for gratification purposes is no defense to the prohibited purpose requirements. That is the same for peacetime rapes in places of detention. So we have the purpose, which has been satisfied as well. Turning to the public official requirements, the UN Convention Against Torture specifies that for conduct to constitute torture, it must have been inflicted by or at the instigation of or with the consent or acquiescence of a public official or other person acting in an official capacity. This is no longer, if it was ever, part of international criminal law. The public official requirement is a problem for gender violence because perpetrators are frequently non-state actors, as we know, whether acting during conflict or peacetime. It leads to the trivialization of gender violence in the private sphere, where such violence is most prevalent, ensuring that it stays hidden. So we can't be complacent with this. This is something which simply must be fixed. Some feminist theorists have sought to say that the public-private distinction is not all that it should be, arguing that because some violence against women has its roots in the structure structuring of society, it cannot be considered simply a matter of the private sphere. But despite these arguments' forcefulness, the arguments have only indirectly impacted the anti-torture framework. Efforts by human rights courts and related bodies to adapt the anti-torture framework to better account for gender-based violence and other forms of harm occurring primarily in the private sphere consist mainly of using due diligence requirements, as has already been discussed, reminding that states must protect individuals from serious pain or suffering occurring in the private sphere. When states fail to do that, they violate their due diligence obligations under international human rights law to prevent and respond to torture and other ill treatment perpetrated by non-state actors. However, the due diligence requirements have not gone so far as to recognize that private actors can or should be prosecuted for torture, for the gender violence that they perpetrate outside of the international criminal law context. There are some exceptions, with some countries having introduced legislation recognizing torture for private actors, but usually it's the countries which have had issues with rebel movements. So you have that kind of context being the impetus to engage with private actor torture. It's not a matter of trying to deal with gender-based violence in general. Also, the due diligence expansion has not led to state officials being prosecuted for torture as opposed to other lesser crimes when they fail to protect individuals from the violence caused by these private actors. So we still have a lot of work to do. To conclude, some would query whether the constraints associated with fitting gender violence within the box of torture are so fundamental that they undermine the legitimacy and capacity of the torture framework to serve as a useful tool to advance and ultimately to afford gender justice. I think that is a valid question, but the definition of torture should apply to the most serious forms of human suffering. And we know that gender violence is amongst the most severe forms of human suffering. So there is no issue there. The definition of torture is not and should not be available to only certain forms of harm by only privileged, already visibilized persons. That is what we mean by equality, diversity, and non-discrimination. It's a fundamental part of how human rights must be seen, used, and implemented. Thank you.
Well, thank you very much. So you really said what I think everybody in the room thinks. So why something that we know what it is, we think we know what torture is, why should it be only something that is defined as state actors' competence or guilt? So on the basis of this, I think that if we advance swiftly, we may have a discussion later. I would like now to give the floor to Dr. Manfred Novak, who knows quite a lot about this. He was special rapporteur on torture for 10 years?
6 years.
6 years, okay. Let's go to this. Dr. Novak, please.
Thanks very much. Yeah, I think everything has been said by Carla, so there's not anymore much to add. Torture is the deliberate infliction of severe pain or suffering for a certain purpose on a powerless victim. That's the combination of Article 1 of the Convention Against Torture and also their own statute on the International Criminal Court. If we apply that, one of the purposes explicitly mentioned is discrimination. Gender-based violence is by definition discrimination against women or under other gender identities. So I think there is no question that if the other requirements, that means severe pain or suffering, not every form of violence leads to severe pain or suffering. But as you said, rape and other similar forms of gender-based violence, of course, cause severe pain or suffering. They are discriminatory and the victims are powerless. So of course, this is torture. Then we have always this problem with the state nexus. Where does it come from? And that's quite interesting also, and I'm happy that the ambassador of Honduras is among us today and is supporting this because it comes from the Latin Americans. The Convention Against Torture was a reaction to systematic practice of torture in the national security dictatorships all over Latin America. And the Latin Americans said, we want to have this special stigma for state officials, military, police, who were torturing us, and we are less concerned about the non-state actors. We had exactly the same discussion when we drafted the Convention on Enforced Disappearances, which was in the 2000s. And even there, still the Gulag said primarily, but still, again, it's a difference whether it's the Sendero Luminoso or whether it's the military in Argentina. So that's where the state nexus comes from, and the traditional form that we only can hold states accountable under international law. So that's the reason why. But it says, as you said already, not only by public officials, but also at the instigation and with the acquiescence. And I think that leaves a room for interpretation. When I was special rapporteur on torture, for instance, if we are talking about female genital mutilation and other traditional forms of violence against women, it was always clear that there is a state responsibility. Of course, FGM as such is torture. There is no question. The question is, can you hold the state accountable for every individual case of FGM or domestic violence by an intimate partner? That is the question of due diligence. If the state, what can be reasonably expected from the state to do in order to protect these victims, girls, women, against the perpetrators? And if not enough is done, then the state is also accountable and can be held accountable under international law for not having protected enough the victims. I think I also want, because when we originally discussed it, is femicide torture? Do we have to redefine torture in order to bring femicide under this definition? I don't think so. I think these are two different things. Femicide as such is a very serious crime, and it's usually defined as the intentional killing of girls or women because they are girls or women. Of course, if the perpetrator, when committing femicide, is again deliberately causing severe pain or suffering, etc., then it also amounts to torture. But many killings of women might not even be intentional, and nevertheless femicide. And they might not really show the intention of the perpetrator to really cause severe pain or suffering if they simply want to kill the women. So there might be cases where femicide amounts to torture, but at the same time, it is one of the worst crimes. It's a very serious crime. So not every serious crime needs also to be called torture. Torture is very specifically defined. It's one of the worst human rights violations and worst crimes. And there's often a lot of overlapping. The same is with trafficking. Trafficking can amount to torture, but doesn't have to amount to torture. So to answer the question, do we have to redefine torture? I don't think so. I think we have a very clear definition of torture. And we can interpret it, and it has been done so already by the Committee Against Torture, by special rapporteurs on torture, and by others applying the prohibition of torture in a very wide sense, so that in any case, gender-based violence that has a specific purpose and that causes severe pain or suffering definitely falls under the definition of torture. Thank you.
So you see, these are all pieces of a puzzle, because apparently the framework is there. So it is the matter of helping make the best use of what we have to make sure that we can use these tools also to prevent these forms, to be a deterrent, to further prevent this form of very serious gender-based violence. At this point, the next speaker, Undersecretary Yulisa Villanueva, unfortunately could not join us. She was she had an impediment, and so she sent the text of her presentation. And so, with your patience, I will read her presentation. Secretary Villanueva, she is a real expert in these topics. Villanueva, okay, you have her, yes, because if you see her CV, it's quite impressive. She was with us on other occasions, and she could share something from her work experience that is quite impressive. She makes a bit of reference in her presentation. So I will read out the statement from Undersecretary Villanueva. Excellencies, delegates, representative of civil society. At the beginning of my speech, allow me to join in expressing gratitude to the co-organizer of this side event and the Alliance of NGOs in Vienna. This thank you is on behalf of the government of Honduras, conveyed by Ambassador Elena Page, permanent representative of Honduras to the UN in Vienna. I would also like to thank my fellow panelists, Carla Feldman, Manfred Novak, and Sven Pfeiffer, as well as our moderator, Nazar. Ladies and gentlemen, gender-based violence in its various forms, as we all know, is the most widespread violation of human rights. My Undersecretary role has a specific mandate to combat all forms of gender-based violence. This is the fourth occasion on which I have had the opportunity to be part of the discussion on the need to stop torture as a form of gender-based violence against women and girls perpetrated by non-state actors. There is a need to reconsider the definition of torture to effectively address gender-based violence. On the first occasion I participated in this discussion, I had the privilege of sharing the panel with Rashida Manjoo, former Special Rapporteur on Violence Against Women and Girls, who visited Honduras from July 1st to 8th, 2014. The Special Rapporteur noted in her report on the visit that 60% of acts of gender-based violence against women and girls were linked to organized crime, gangs, drug traffickers, and human traffickers. She described in her report how the levels of violence aggravated by gangs accounted for many forms of sexual violence and torture perpetrated by these groups. The Special Rapporteur also referred in her report to transnational violence in the context of migration and the harm inflicted on victims of human trafficking. The visit of the Special Rapporteur took place almost a decade ago, and I would like to say that things have improved since then. Unfortunately, this is not the case. This is why being part of and contributing to this discussion is so important for Honduras and the government of President Xiomara Castro. In the first panel we had during the Crime Commission last year, I shared with you my experience as a forensic doctor how the bodies of women and girls speak and reveal that some of them were tortured before being murdered and mutilated. The perpetrators are not state actors, but non-state groups, such as gangs and organized crime. However, they are not punished as torturers, and their victims are not recognized as victims of torture. The Special Rapporteur on Violence Against Women recommended to Honduras to improve our data collection to make evidence-based policies. We cannot continue to ignore or underestimate these forms of violence. The torture against women, which, as stated above, accounts for 60% of the cases. An effective institutional response with due diligence requires scientific information about the nature and the magnitude of the phenomenon in order to protect and repair the victims and impose fair sanctions on the perpetrators, adapting our legal frameworks. This violence is increasing worldwide. This is why Honduras believes in the importance of a declaration that affirms the need to redefine the concept of torture. It should incorporate gender-based violence as one of its elements, in light of the principle of due diligence mentioned by Carla and Manfred in their interventions. I agree with both of them that the current frameworks are insufficient. In conclusion, I reaffirm our government's commitment. You can count on Honduras to continue engaging in their discussion to promote the establishment of national and international frameworks to address gender-based violence, prevent it, combat it, and effectively sanction it. Thank you very much for your attention. I think we should thank and we will make sure to convey the thanks of this room. By the way, we have the recording of that panel that is mentioned. It is on the website of the Alliance, I believe. No? Yeah. So if you go to the website of the Alliance, you will find among the videos there is the YouTube channel and the recording of that particular event that was quite informative. So with many thanks to all the panelists for such an effective time keeping, we have 10 minutes for discussion. I think it's quite a record for these side events here. Questions? Who wants to ask a question? Who first? Please, introduce yourself.
My name is Ivanad, and I'm a legal advisor with Dignity, and that is organization working with victims of torture. And my question is related to due diligence and the state requirement. I've been living in Kenya for the last 8 years and have been part of the group that actually successfully civilly litigated case against the Kenyan government from 2007 to 2008 post-election violence, with 8 victims of sexual and gender-based violence. 4 of them were raped by the military or the police, while 4 of them were raped by the non-state actors. The ones that were raped by the state actors, we clearly proved that the state was responsible, the rights are violated, and the victims are accused of torture. However, the 4 of the victims that were raped by non-state actors were not lucky. And the court literally ruled saying that the only way that the state can be successfully found guilty for violating these rights is if the victim has reported the instances of torture to the police officers or authorities. So my question to you is, can you tell us or the group, how do you see this requirement in terms of when does this requirement of state coming into investigating the torture and providing reparations come into place when often victims do not report the instance of torture because they don't have access to the police, military, or whoever? So how do you rate that? How can the state become aware of these instances, or how would that help?
Thank you very much. How do the panelists want to go? Do we want to collect another question? Are there other urgent questions? Because this is quite a detailed question. There's another. I think it's better if we collect. Please,
Hi, my name is Tibor. I'm from Slovakia. I'm a lawyer and I worked several years at the ICC before and in the court in Cambodia. And I have a question on the state nexus and the definition under Article 1 of the convention. And in Slovakia, under our criminal code, we also have the state nexus, and it's quite limiting with investigating and prosecuting the potential crimes. And I just wanted to ask, what are the chances, or realistic chances, of broadening the definition of Article 1 under Article 1 of the convention, or is it more realistic to do it through push on domestic jurisdiction? Yeah, that's it.
I saw another hand here, please.
My name is Gabriel, part of the Vienna Master. My question primarily directed to Kala. You precisely asserted and also countered the arguments that the inclusion of gender-based violence under torture would be a dilution of the severity of torture. My question then is, with that notwithstanding, wouldn't it be more efficient if we focus more efforts towards strengthening the already existing plans of putting gender-based violence as a unit of its own, with its own severity, instead of it being a subcategory to torture? So for instance, we already have war crimes and crimes against humanity, which are categories of their own. So then wouldn't it be more efficient if gender-based violence is a subset, an entity of its own, instead of it being subservient to torture?
Okay, so we have now 3 questions. How do we go? We go back to the panelists in order, and you can address all 3 questions as you deem. So Sven, first.
Okay, well, I'm not actually the torture expert, so I have probably to say, but
Your,
just
your comment.
to what you just said last, I think this is also a question I have actually, because we've been working on this topic not being part of the human rights framework and the torture convention on the special procedure. We take a broader perspective based on those instruments that are outlined in my initial intervention. So for us, it would be one of the forms of gender-based violence against women that would need to be addressed, just like trafficking is one of the forms of gender-based violence, or domestic violence, or sexual violence, or FGM. So in our approach, we wouldn't make any difference. We would go through the list that we have of steps, and based on the mandate, sometimes we have an opportunity to review laws and spot any gaps or flag to countries, any gaps that they might wish to consider addressing. And this is certainly very interesting and something we would flag, but we would look at all crimes of violence against women and try to enhance reporting in general of rape. Things like sexual assault nurses programs in the US is a good practice that we promote through tools, for example. Also, sometimes victims do not want to come forward now, but states a good practice we think is that in some hospitals there's the option that you can make a report and tell them to keep it confidential and on the record until you're ready to go forward with the criminal justice process, which is quite re-traumatizing in many cases. There's many deficiencies. States are not living up to their due diligence obligations, as I mentioned. So when the victim is ready, then the testimony is there and can be used in the legal process. That's just one example of how we could enhance reporting or accountability later in those very difficult cases. That's the reflections I have to offer.
Thank you.
So many questions and good questions. Thank you. With respect to the last points, I don't see that gender-based violence dilutes torture, because I think what we need to continue to reflect upon is the nature of the harm. And the nature of that harm is so severe that we shouldn't think of it as diluting torture. So that's one part of it. I think we need more forensic analysis. We need more understanding globally about the harm, so that we stop having that gradation or feel that torture is only about this one thing. Gender-based violence is part of that horrible harm that we think about when we think about torture. That's really the point. Should there be more specific focus on gender-based violence in terms of its own treaty? Absolutely. We know at the regional level, there have been many developments, and these have been really important. The Istanbul Convention, the Convention de Belém de Pará in the Americas and in Africa as well. So I think to have a global convention on violence against women that deals specifically with this kind of violence is absolutely important. On the other questions, to go back to Eva's question, I think there's two points here. One has to do with privacy, in the sense that one wouldn't want to have a situation where cases are being brought without the consent and taking into account the wishes of the victims because of the sensitivities involved. So that would be one side. But the other side of the issue, in terms of the human rights component of the obligation to investigate, has to do with proprio motu investigations. States have an obligation to investigate, which commences when they hear about the events or when they should have heard about the events, depending on the context. So knowing a little bit about those cases, I think there's certain problems that need to be dealt with in that sense. On the middle question, I would say I think really we need more interpretive guidance, perhaps, at the international level in terms of the treaties and domestic jurisdiction. There's already a lot of domestic laws that are going in this direction. We need to be a little bit careful, though. There's a reason why state violence is basically the fact that the state is there to protect and the state is instead committing violence is something that we don't want to get away from within the torture definition, but expanding and having additional ways to deal with these issues are really important. I'll stop there. Thank you.
Thank you very much.
Yeah, I start also with the Slovakian question. Of course, and we were always telling states that you only have an obligation under the Convention Against Torture to criminalize torture as defined in the convention that has the state nexus. But you should actually go beyond, and there's no reason, because in criminal law, there shouldn't be any kind of distinction. The Rome Statute, there's no distinction, there's no state nexus. So, of course, under the domestic law, you should have torture by state and non-state actors alike. You might have a higher penalty if it's a state actor, but in any case, private torture should be also criminalized, but there is no legal obligation. To Eva, I just agree with Carla. Of course, it is, as long as the state is not informed, it's very, very difficult to start with the due diligence obligation. So you can try to have better means of awareness raising and having special police that is trained in order to look into domestic violence, etc., so that there are easier channels of reporting. But if, nevertheless, the woman, for whatever reasons, is not reporting, it's difficult to actually trigger the due diligence obligation. And on Gabriel, I mean, there are many, if you look into the Rome Statute, Article 7.1g, you have rape, sexual slavery, and forced prostitution, forced pregnancy, and forced sterilization, many other forms of sexual violence that are actually a crime against humanity if committed as part of a widespread attack, etc. The Mobutu Protocol of the African Charter on Human and People's Rights is very, very clear. Traditional forms of violence against women as FGM, etc., are explicitly outlawed and should also be criminalized. So I think there are many different forms of sexual violence that are explicitly mentioned, should be criminalized. If you at the same time put them in the context of torture, they might have a stronger stigma and perhaps a better protection under criminal law, but you can also have them as separate crimes, as stated in so many. I mean, also the ICTY actually developed as crimes against humanity and war crimes, many forms of specific acts of violence against women in the former Yugoslavia.
Thank you very much. Thank you. I would like to thank all the panelists for this very important discussion, and thank you also to all the participants for being here so numerous. Thank you again to Ambassador Perez for your support and the support of your country. It's very, very important for us. It gives us hope that we can open a dialogue with the state. I would like to thank also Evelyn Dormeyer and Ingeborg Geyer, who is somewhere there. Inge will host the next event in this room, so she's a bit impatient, so that's where we leave. But thank you all.